Welcome to the deep dive. Ever get tangled up thinking about the rules for trusts, like who really owns land in a trust, how we'll set them up, or how you even pass on your share in one?
Yeah, those formalities can seem a bit daunting.
Exactly. So today we're diving into that. We're looking at declarations of trust for land, the rules for trusts made in wills, testamentary trusts, and how you transfer your bit of an existing trust.
Three really key areas. Get them wrong, and, well, it can get messy.
Definitely messy. We're using some great materials from the University of London today, and a big thanks to Sonorbit Academy, Sri Lanka, for making this available for educational purposes.
Absolutely. This is all about understanding the core ideas, not getting bogged down in, endless legal speak.
Right. Educational deep dive. So
Yeah.
first stop,
Yeah.
declaring trusts of land. What's the starting point here?
Okay, so land trusts. The big piece of law you need in your head is Section 53, subsection 1, paragraph B. That's the Law of Property Act 1925.
Section 53, 1B, LPA 1925.
Okay, yeah. It actually replaced a much older law, the Statute of Frauds from 1677, but the main idea stuck.
And what's that main idea?
It says any declaration of trust about land has to be manifested and proved by some writing, and that writing needs to be signed by the person who can actually declare the trust, or it has to be in their will.
Manifested and proved by some writing.
Okay, sounds simple enough. Does that mean if I just tell someone, hey, I'm holding this house on trust for you, but don't write it down, the trust just doesn't exist?
That's a really common misconception.
Yeah.
Section 531B isn't actually saying the trust is invalid if it's only spoken.
Oh.
It's more about proving it exists later on.
Yeah.
It's an evidence rule, so you could, in theory, have a valid oral trust of land.
But there's always a but, isn't there?
But trying to convince a judge it happened without any signed writing, good luck. It's practically impossible to enforce. So the trust might be there in principle, but useless without the proof.
I see. So rule of evidence, not validity. That makes a big difference. What's for land, though? What's the big worry? Think about the old name, Statute of Frauds. The whole point was to stop people making dodgy claims,
Right.
to stop someone popping up and saying, oh yeah, Bob told me last year he was holding his farm on trust for me, when Bob never said anything of the sort. It protects landowners from made-up claims.
Makes sense. Protecting owners from false claims. Okay, what about timing? Does the writing have to be done right there and then when the trust is declared?
No, actually, the law's a bit flexible here. The written proof can come later.
Really?
Yeah. The key thing is having some signed writing at some point that shows a declaration was made earlier. You could agree verbally today and sign a note confirming it next week.
Yep.
That note would work.
Okay, that's interesting. Bit more practical. But what if there's just no writing ever? And it seems really unfair. Are there, like, exceptions?
Absolutely. And this leads us to a really, really important case. It's called Rochefoucauld v. Bousted from 1897.
Rochefoucauld v. Bousted, 1897. Okay, sounds important. What happened?
Right. So you had the Countess of Rochefoucauld. She transferred some land to this guy, Bousted. She said they had a clear agreement. He was just holding it on trust for her.
But let me guess, nothing in writing.
Exactly. Zero written evidence of this trust agreement. So Bousted naturally argued, hey, Statute of Fraud says no writing, no trust. Tough luck, Countess.
Based on what we just said, sounds like he had a point.
He did, legally speaking. But the Court of Appeal wasn't having it. They said, hang on, this statute was made to prevent fraud.
Right?
We're not going to let Bousted use the statute as an instrument to commit a fraud. Allowing him to deny the trust, when they knew he'd agreed to it, would itself be fraudulent.
Wow, so they basically said the law can't be twisted to help someone be dishonest.
Precisely. Equity steps in. They allowed oral evidence of the agreement to be heard. It's a massive principle. Equity won't let a statute be used as an engine of fraud. Remember that one. Rochefoucauld v. Bousted.
Definitely remembering Rochefoucauld v. Bousted, 1897.
So what kind of trust did the court say it was then, if it wasn't written? They held it was an express trust. It arose from the declaration they'd managed to prove using the oral evidence, which they only allowed because of the fraud exception.
An express trust, even though it wasn't written down as required.
Yes, because the requirement in 53 1B is evidential. Now, fair warning, some later lawyers and judges have sometimes talked about these situations creating constructive trusts.
Yeah, okay. Why the confusion?
I think it stems from misunderstanding 53 1B. People think it makes the oral trust invalid, so something else, like a constructive trust, must be happening. But the Rochefoucauld case itself was clear. It enforced the express trust that was declared. That's the main takeaway from Rochefoucauld v. Bousted, 1897.
Okay, so Rochefoucauld is the big judge-made exception to prevent fraud under 53 1B. Are there any exceptions actually written into the Act itself?
Yes, there are. Section 53, subsection 2, so 532, directly says that the writing requirement in 53(1)b does not apply to resulting, implied, or constructive trusts.
Right. And why is that?
Because those kinds of trusts don't arise from someone explicitly declaring a trust in the first place. They arise automatically by law because of the circumstances or people's conduct. Like constructive trusts often pop up based on how people have acted, their intentions inferred from behavior.
So things like those family home disputes,
Yeah,
where maybe a couple buys a house, but it's only in one person's name.
exactly. Cases like Gissing v. Gissing back in 1970, they often involve finding a common intention constructive trust.
Right.
These are usually covered in property law, but the point is they're based on actions and inferred intentions, not a formal declaration needing written proof under 583. They fall under that 533 exception for constructive trusts.
Okay, so Gissing v. Gissing is a good example there for constructive trusts arising from conduct. That clarifies the land trust rules. Section 731B for written evidence, or Chavoso for the fraud exception, and 532 excluding resulting, implied, and constructive trusts. Let's shift gears. Testamentary trusts.
Right. Trusts made in wills. These kick in when the person making the trust, the settlor, dies.
And the key law here, not the LPA 1925 anymore.
No, here we're looking at the Wills Act 1837, specifically Section 9. This sets out very strict rules for making a valid will.
Okay, Section 9, Wills Act 1837. What are these strict rules? More than just writing it down, I assume.
Oh yeah, much more. First, it absolutely must be in writing. Second, the testator, the person making the will, has to sign it. Or someone else can sign for them, but only if the testator is there and directs them to.
Okay, writing, signature, what else?
Third, it's got to be clear the testator intended their signature to make the will legally valid. Fourth, and this is a big one, the signing or acknowledging the signature must happen in the presence of two or more witnesses.
Two witnesses.
Yes, and crucially, they both have to be present at the same time when the testator signs or acknowledges.
Wow, okay, both there together.
And then fifth, each witness has to sign the will themselves or acknowledge their signature in the presence of the testator. They don't necessarily need to sign in front of each other, but the testator must be present when they do.
So Wills Act 1837, Section 9. Writing. Testator's signature with intent. Two witnesses present together. Witnesses sign in testator's presence. That's quite a performance.
It is. It's designed to be very formal to prevent fraud and ensure it really reflects the testator's wishes. And remember, will covers codicils, amendments, anything that disposes of property on death. Section 1 of the Act makes that clear.
How does the Section 9 compare to the rules we just talked about? It feels different from the evidence rule for land trust.
It does feel different. Section 9 looks much more like a rule about the validity of the will itself. If you don't follow these steps, generally the will is invalid. Full stop. No will, no testamentary trust within it.
So it's not just hard to prove, it's actually void?
Usually, yes. It's stricter than a 531B. It looks a bit more like Section 531C, which we'll get to, requiring the actual disposition to be written. However, there's always a however in law, isn't there?
Seems like it.
When we talk about secret trusts later, you'll see courts sometimes bend these rules a bit, treating Section 9 almost like an evidence rule in specific cases to prevent fraud. But for standard wills, Section 9 of the Wills Act 1837 is king. Stick to the letter.
Got it. Strict compliance needed. And one last thing on wills. When do they actually matter? When do they bite?
Only on death. Absolutely crucial. You can make a perfectly valid will today following all the Section 9 rules, but it has zero legal effect while you're alive.
So I can change my mind tomorrow?
Yep. Rip it up, make a new one, whatever. It only becomes legally binding the moment the testator dies. Before that, it's just a plan.
A plan with no power until death.
That's it.
Okay, testamentary trusts and Section 9 of the Wills Act 1837 are clear. Let's tackle the third area, transferring interests under existing trusts.
Right. So the trust is already up and running. Someone is a beneficiary, maybe getting income or entitled to capital later. We're talking about how they give that existing interest away to someone else.
Can beneficiaries even do that?
Yes, if it's a fixed trust where their share is defined, beneficiaries usually have an equitable interest they can assign, like any other asset.
And are there rules for how they do that? More writing involved.
You bet. This is governed by Section 53, subsection 1, paragraph C of the Law of Property Act 1925. So back to the LPA.
Okay, Section 53(1)(c), what does it say?
It states, and this is important, A disposition of an equitable interest or trust subsisting at the time of the disposition must be in writing signed by the person disposing of the same or by his agent thereunto, lawfully authorized in writing or by will.
Must be in writing signed. That sounds non-negotiable. What if you try to do it verbally?
Then it's void. Absolutely no effect. This isn't just hard to prove. The law says the disposition simply hasn't happened until it's in writing and signed.
Void, not just unenforceable.
Exactly. The key case here is Gray v. Inland Revenue Commissioners, often just called Gray v. IRC. It went to the House of Lords in 1959. They made it crystal clear. No writing, no disposition. The transfer only occurs when the written document is signed.
So, Gray v. IRC, 1959, essential for Section 531C. What counts as a disposition? Is it just signing your interest over directly?
No, the courts, especially in Gray v. IRC, interpreted disposition very broadly. It covers lots of ways you might try to move your beneficial interest around.
Like what? Can you give some examples? And maybe the cases?
Sure. The classic one from Gray v. IRC itself is telling your trustees, stop holding my interest for me, hold it for my kids instead. That direction is a disposition. Needs writing.
Okay. Telling trustees to hold for someone else. What else?
Telling the trustee to transfer the legal title to someone else, intending the beneficial interest to go with it. That came up in Vandervelde v. IRC in 1966. We need to talk more about Vandervelde later. It's got a twist.
Okay, Vandervelde, 1966. Noted. Any others?
What if you hold an equitable interest and you declare yourself a trustee of that interest for someone else, creating a subtrust?
Like a trust within a trust.
Exactly. Cases like Nelson v. Greening and Sykes in 2007 and a recent one, LA Micro Group in 2023, suggest that this also counts as a disposition under 531C and needs writing.
Even creating a subtrust needs writing. Interesting. Keep going.
Okay, what if the trustee declares they now hold for a new person, but only because the original beneficiary told them to or agreed? That was looked at in Vandervelde's Trusts, number 2, in 1974. That consent or direction, disposition, needs writing.
Right.
Also, making a contract to assign your equitable interest, that was controversial, but cases like Oughtred v. IRC, also 1959, and later Neville v. Wilson, 1997, and again LA Micro Group, 2023, point towards needing writing under 531C, although there's some interaction with constructive trusts there too.
Contracts to assign. Complex. Anything else, Scott?
Yes, simpler things too, just giving up or surrendering your interest back to the trust. That was IRC v. Buchanan in 1958. Needs writing. Or formally disclaiming an interest you were meant to inherit under a trust. Paradise Motors from 1968 suggests that's a disposition needing writing too.
Wow, okay. So the list of dispositions under 531C is long. We've got directing trustees, Gray, transferring legal title, Vandervelde, creating subtrusts, Nelson, LA Micro, trustee declaring with consent, Vandervelde number 2, contracts to assign, Oughtred, Neville, LA Micro, surrender, Buchanan, and disclaimer, Paradise Motors. It really covers a lot of ground.
It does. The courts wanted to cast the net wide to catch attempts to move equitable interests without formality.
And the reason behind 531C, like 531B, is fraud prevention again.
Yes, fundamentally. Both come from the statute of frauds lineage. But the specific fraud 531C targets is slightly different. Vandervelde v. IRC, that 1966 case, is helpful here.
How so? What was the issue in Vandervelde?
Mr. Vandervelde was the beneficiary of shares held by a bank on a bare trust for him. He orally told the bank, transfer those shares to the Royal College of Surgeons. I want them to own them completely. The bank did. Legal title transferred.
Okay. Seems straightforward.
But the taxman argued Vandervelde still owned the equitable interest because his instruction to the bank wasn't in writing, as required by Section 531C.
The writing requirement strikes again. But didn't the House of Lords find a way around it in Vandervelde? You mentioned a twist.
They did. They disagreed with the taxman. Their reasoning was about the purpose of 531C. They said the main reason for the writing rule is to protect the trustees.
Protect the trustees. How is...
So they don't pay out the trust fund to the wrong person. If someone claims the beneficiary orally assigned their interest to them, the trustees can say, show us the signed writing required by 531C. It avoids them getting sued for breach of trust if they act on a dodgy oral instruction.
Right. It gives them proof before they act.
Exactly. But in Vandervelde's situation, he wasn't just moving the equitable interest while keeping the trust going. He was telling the trustee to transfer the legal title away completely, intending the Royal College to get everything legal and equitable. The trust was meant to end.
So no trust. No trustees left to protect.
Precisely. The House of Lords said because the intention was to collapse the trust structure entirely and pass absolute ownership, the protective purpose of 531c wasn't relevant anymore. So, in that specific scenario where legal and beneficial title are moved together on the beneficiary's direction to end the trust, Section 531c doesn't apply. That's the Vanderbilt exception.
That's a really neat piece of reasoning. The Vanderbilt exception from 1966, 531c, doesn't apply when you transfer legal and equitable title together to end the trust. Can you just restate that exception clearly one more time?
Sure. The Vanderbilt exception is this. When a beneficiary who owns the entire equitable interest under a bare trust and has the capacity to do it directs their trustee to transfer the legal title to a third party, and the intention is clear that this third party should receive both the legal and the equitable title, absolutely effectively ending the trust, then that transaction does not need to comply with the writing requirement of Section 531c of the Law of Property Act 1925.
Okay, that's clear. But thinking back, you mentioned Gray v. IRC earlier, where the beneficiary just told the trustees to hold for someone else. The court said that needed writing. Isn't there a bit of tension there?
You've spotted a classic point of legal debate. Yes, there is potential tension.
How so?
Well, if the point of 531c is mainly to protect trustees, as Vanderbilt suggested, think about Gray. In Gray, the trustees got a direct oral instruction from Mr. Gray, the undisputed current beneficiary. They knew exactly who was telling them what to do.
Right. So arguably, they weren't really at risk of acting on a fraudulent claim in that specific situation.
Exactly. You could argue that forcing Mr. Gray to put his clear instruction in writing didn't actually add much protection for those trustees in that moment. They already knew what he wanted.
So Gray's insistence on writing might go a bit beyond the trustee protection rationale highlighted in Vanderbilt.
That's the argument some people make. It suggests maybe the interpretation of disposition in Gray was broader than just protecting trustees, or maybe the reasoning in the two cases isn't perfectly aligned. It's one of those fascinating areas where top judges reach slightly different conclusions based on, perhaps, emphasizing different aspects of the law's purpose.
Okay, that's a really interesting nuance between Gray and Vanderbilt. This has been incredibly helpful, covering so much ground. Let's just quickly pull the threads together.
Sure. We looked at three main formality requirements. First, declaring land trusts. Section 53(1)b of the LPA 1925 needs written evidence, but the trust can be declared orally. Key exception. Rochefoucauld v. Bousted from 1897 stops the rule being used for fraud. And remember, Section 532 excludes resulting, implied, and constructive trusts. Second, testamentary trusts. Made in wills. Very strict rules under Section 9 of the Wills Act 1837. Writing, signed by testator with intent, two witnesses present together. Witnesses sign in testator's presence. Crucially, the will only works upon death.
Okay. And third,
transferring existing equitable interests. Section 531c of the LPA 1925 requires the disposition itself to be in writing and signed, otherwise it's void. Remember Gray v. IRC from 1959. Disposition is read broadly. But there's the big Vanderbilt v. IRC exception from 1966 for when legal and equitable title move together to end the trust.
fantastic summary. Absolutely vital stuff if you're involved with trusts, property, or planning inheritances. It really shows that balancing act the law tries to perform, doesn't it? Preventing fraud, but also trying to make sure people's real wishes are followed.
It's a constant tension.
Maybe a final thought for you, our listener, to ponder. How well do you think these rules, some quite old, actually work today? Do they strike the right balance between stopping scams and letting genuine intentions take effect in our modern world? Are they still fit for purpose?
Definitely worth thinking about. And do look up those cases we mentioned, Rochefoucauld, Gray, Vanderbilt. Reading them really brings the principles to life.
Absolutely. Well, that wraps up our deep dive into trust formalities. Remember, this was purely for educational purposes, using materials from the University of London, brought to you by Sundorbit Academy, Sri Lanka. Thanks for joining us.